If you are a gig worker or an independent contractor, something huge happened today that you need to know about. Millions of gig workers like home care workers, construction workers, truckers, maybe even rideshare drivers or food delivery drivers may now be entitled to employee benefits like sick time, overtime pay, and health care. That could impact millions of workers across the United States, maybe even you. The Department of Labor announced a brand new federal rule today that changes the existing tests that employers use to classify their workers as either employees or 1099 independent contractors under the Fair Labor Standards Act of 1938. Now, in case you don't know, independent contractors don't receive federal labor protections like minimum wage or work comp or unemployment benefits. But on the flip side, they set their own schedules, they do the types of jobs they want, and they work for whichever companies they want. The problem is some companies improperly count their actual employees as independent contractors so they can avoid paying for the benefits that a normal employee would be entitled to. But not anymore. So under this new rule released today, the Labor Department has returned to the more traditional 6-factor tests that employers have to go through when they classify whether their worker is an employee or an independent contractor. This new rule requires a multi-factor analysis that was used for decades before former President Trump changed it to make it a little more employer-friendly. So what types of things do employers now have to weigh when they determine if a worker is an employee or independent contractor? The new test, as I said, considers 6 factors. I'm not going to go through all of them because they're super technical, but I'm going to share some examples so you sort of understand what I'm talking about. So one example of the test is opportunity for profit or loss depending on managerial skill. But what it means is, can a worker negotiate the pay, accept or decline projects or duties, or choose the order in which those tasks are completed? If yes, then that worker is probably going to be classified as an independent contractor. Another example of the test. What degree of permanence is included in this work relationship? So if the working relationship between worker and employer is continuous and sort of indefinite, that could indicate that this worker is actually an employee. But when the worker has an end date, is non-exclusive, and based on the worker providing a service to a business, that worker is probably going to be classified as an independent contractor. Another test is, what's the nature and degree of control an employer has over a worker? Does the employer set the work schedule, supervise the performance of the work, explicitly limit the worker's ability to work for others? If yes, that worker is an employee. The easiest way to really think of this generally is whether the worker is economically dependent on the employer for work. If yes, the worker is classified as an employee. But if the worker is in business for themselves and just doing a service for an employer, that worker is classified as an independent contractor. This new rule, which was first introduced back in October of 2022, does not affect other federal, state, or local laws that use different standards for employee classifications, including in states like California and New Jersey that use what's called the ABC test to determine wage and hour laws. This new federal test will take effect on March 11th of this year. Now, most of the people who drive for companies like Uber and Lyft are independent contractors, and those companies have fought very costly and very long legal and legislative battles in states like California to keep it that way. They say if the government makes them classify those independent contractor drivers as employees of the company, that would cripple their business because there would be no way they could pay those drivers salaries and give them overtime and medical insurance while also keeping costs down for those who use the service. So when it comes to this new rule, those rideshare companies all say they are confident they can comply with this new rule and keep their drivers as independent contractors. But that might not be the case for lots of other businesses across the country. So we are definitely in for lots of legal battles ahead. Now, if you want to read more about this new rule when it comes to independent contractor versus employee, I will email it out to you tonight in my News Girl News Roundup email, so make sure you sign yourself up.